Good evening, everyone, and welcome to the Prince George's County Memorial Library System and Office of Human Rights joint virtual program series. We're also joined tonight by Joe's Movement Emporium, Maryland Humanities, and the Prince George's Center for, Community College Center for Performing Arts. Tonight, we have a very special program for you entitled Freedom Suits and the Law. This is part of our Freedom Stories two-year initiative, which discovers the histories, stories, names, and places where freedom from enslavement and oppression began in Prince George's County. Through dialogue facilitated by programs, Freedom Stories strives to connect legacy to present-day Prince George's families and provide insight into the determination and resilience of Blacks living in the county as early as the 1700s. We explore the history to create a more just and equitable present experience. Part of Freedom Stories is exploring the history of these enslaved families in our county who were amazingly courageous and used the judicial system to achieve, in many cases, freedom when it was unheard of in the late 1700s and early 1800s. We have been navigating through this work with a very special book, which is our 2021-22 Prince George's County Read. It is called A Question of Freedom by William G. Thomas, who is a wonderful friend of our organizations. And we are grateful for him doing this work as a historian and making it accessible to us to interpret and help build community with. The work of this Freedom Stories project will culminate in a new play written by Salma Renee, 24, which will be workshopped and presented over the course of the rest of calendar year 2022 and into the future. Tonight we're doing a deep dive into the legal issues related to the freedom suits. And we have three very distinguished guests with us tonight. Some may be familiar, some may be new to you, and we're very grateful to all of them for spending time with us this evening. Our moderator this evening is Renee Battle-Brooks, and she is the Executive Director of the Prince George's County Office of Human Rights. She has spent most of her legal career as a litigator, as an assistant public defender in Maryland, and also as an assistant state's attorney for Prince George's County, where she spent almost 19 years prosecuting child abuse, sexual assault, and human trafficking crimes. In December 2018, Ms. Battle-Brooks was appointed as the Executive Director of the county's Human Relations Commission, now named the Office of Human Rights, excuse me. And so many alerts. The Office of Human Rights investigates complaints of discrimination, oversees the county's Human Trafficking Task Force, manages an immigrant defense program, has responsibility for the county's language access compliance program, builds understanding across diverse communities through robust outreach, and recently started a youth leadership academy. Ms. Battle-Brooks lends her services to community issues and groups, has served on the Maryland Coalition Against Sexual Assault Board as president and board member, and is a violinist playing regularly with the New England Symphonic Ensemble. We have two distinguished panelists joining us tonight. The first is Judge Sean D. Wallace, who is a judge of the Circuit Court for the 7th Circuit of Maryland. He was appointed to the court in 2002, elected that year to a 15-year term, and in 2018 won election to another term. For most of his time on the bench, Judge Wallace has presided over complex civil litigation, including business and commercial disputes, in addition to major criminal prosecution. He's also been designated to sit on the Maryland Court of Special Appeals. Judge Wallace is a founding member of the American College of Business Court Judges and was president in 2013 to 14. He also served as business court representative to the business law section of the American Bar Association from 2010 to 12. He served as vice chairman of the Business and Commercial Courts Committee of the National Conference of State Trial Judges in 2006 to 2007. And he also chaired the Maryland Judiciary's Subcommittee on Business and Technology Case Management in 2015 to 2021. In 2021, he was selected to chair the newly created Committee on Complex Litigation. We have very distinguished guests, so we've got a little more to get through in terms of their accolades, but it's important to know that we have really serious expertise with us tonight. Judge Wallace was elected as an inaugural fellow of the Advanced Science and Technology Adjudication Resource Center in 2006. Served on the Judicial Advisory Board for the Law and Economics Center at George Mason University's Scalia Law School. He has served in that capacity since 2009, and he has lectured frequently on various legal topics, including through the International Judicial Academy, the Practicing Law Institute in New York City, and Georgetown University's Law Center's CLE programs, the Judicial Institute of Maryland, the ACBCJ, and the Maryland New Trial Judges Orientation. He was also adjunct faculty of the National College of District Attorneys, lecturing regularly across the country from 2002 to 2006, and has been active in international rule of law efforts since 2014, which involved training judges from China, Kenya, and Nigeria, and he's also consulted with judges from Myanmar and Tunisia. Prior to his appointment to the bench, Judge Wallace was county attorney and represented the county before federal and state trial and appellate courts. He was also in private practice for a number of years, focused mainly on federal and state litigation. He received his JD from the University of Maryland School of Law in 1985 and his undergrad degree from Hampton-Sydney College in 1982. In 2001, he was a resident in the Harvard University Program for Senior Executives in State and Local Government. Judge Wallace is admitted to practice in the courts of Maryland and DC, as well as many federal courts at both the trial and appellate levels. He served on the Board of Governors of the Maryland State Bar Association from 2003 to 2005 and was president of the county's Bar Association the prior year. He's also served 16 years on the Maryland Attorney's Grievance Commission Peer Review Committee before ascending to the bench. And he has been active in the Digs Inn of Court, excuse me if I pronounce that incorrectly, from 1986 to 88, and the Sutherland, Maryland Inn of Court, 2011 to present. Gabriel Christian, who is our other distinguished panelist, is a highly skilled veteran trial lawyer attorney and a Georgetown Law School graduate. His areas of legal practice include personal injury litigation, criminal defense, church and religious organizations, international law, commercial law, business organizations, family law, personal injury, environmental law, and sustainable energy law. So he is gainfully employed for eternity with all of those practice areas. He's deeply involved in community service, offering his time to the citizens of Maryland, business organizations, religious organizations, the school system, and the Caribbean community. He's also an accomplished writer with public works, including In Search of Eden, Dominica, The Travails of a Caribbean Mini-State, Rain on a Tin Roof, Death by Fire, The Explosive Story of the 1962 Carnival Tragedy, For King and Country, The Service and Sacrifice of the Dominican Soldier, For King and Country, The Service and Sacrifice of the British West Indian Military, and Mamo, The Life and Times of Dame Mary Eugenia Charles. Mr. Christian is a member of the J. Franklin Bourne Bar Association, the Prince George's County Bar Association, Maryland Bar Association, National Bar Association, Goldstein Inns of Court, Alan J. Goldstein Inns of Court American Bar Association, Dominica Academy of Arts and Sciences, Tuskegee Airmen Association East Coast Chapter, and is a board member of the Caribbean Research and Policy Center. He was appointed a judicial commissioner on the Maryland Courts of Appeals Nomination Commission in 2007 and appointed a commissioner on the Governor's Commission on Caribbean Affairs in 2012 by Maryland Governor Martin O'Malley. We made it. Awesome. Thank you, everyone, for listening to the important accomplishments of our speakers this evening. So our format for the program is that Judge Wallace is going to present first for a bit, and then Mr. Christian will present, and then Renee will come on with both of our panelists to share a moderated conversation, which will take your questions. So without further ado, I'm going to swap out here and welcome Judge Wallace.
Great. Thank you, Nick. I first heard about this book, A Question of Freedom, when I read a book review in the Washington Post last year. I was intrigued by the idea that slaves had sued for their freedom in Maryland and DC courts from the earliest days of the United States, and that they had done so successfully. I was aware that free blacks existed before the Emancipation Proclamation, but I thought that they were free because they had bought their freedom somehow, they had escaped from their captors, or they had been freed for some reason by their enslavers. I had no idea that many had won their freedom in Prince George's County courts. So having read the book review, I ran out, bought a copy of the book, and learned incredible things about my hometown, my church, and my profession. So much of the book focuses on people enslaved at Jesuit plantations in Prince George's County and other southern Maryland counties that now make up the 7th Judicial Circuit of Maryland, where I work. Primary amongst these, particularly in the book, is the White Marsh Manor plantation, which was located in Bowie, where I grew up. I attended Mass at the Sacred Heart Catholic Church, which is there on the site of the former White Marsh Manor. And I was there probably hundreds of times, and I knew a little bit of its history, such as that the old chapel on the hill was where a bunch of priests had met, and they organized the Roman Catholic Church in the United States, that it was the same place where they had voted to request that the Pope in Rome name John Carroll, a Marylander, as the first American bishop, and also the place where they discussed plans to establish Georgetown University. Most of what I knew about the Jesuits, which is the name for people who belong to the Society of Jesus, was a Catholic order was that their current commitment to educating men and women for others is the phraseology at various schools, including my daughter's college. What I learned from the book was that 200 years ago, these Jesuits, the men and women for others, were men who owned others. They were men who enslaved hundreds and hundreds of black men and women as mere property to work on their plantations. And from the book, I learned about the justice system here in this vicinity and how it dealt with the legal issues of slavery. I had known a little bit about this already. Of course, I knew that slavery was once legal in Maryland, and at that time that people could be considered as property. About a dozen years ago, a particular case was brought to my attention. I was presiding over a case, and the attorney cited an 1857 decision from Maryland's highest court, the Maryland Court of Appeals. And it was an appeal from the Circuit Court for Prince George's County, where I sit. The case is called Waring versus Edmonds, and it examined the validity of a donatio mortis causa, which is Latin for a donation as a result of death. And the gift in this case was from one sister to another. The gift consisted of a bond and, in language from the opinion, 3 Negro slaves, Louisa, aged about 10 years, Marie, aged about 4 or 5 years, and Emmeline, aged about 8 years. The issue in the case was not whether someone could give away could own a human being such that they could give it away to someone else. The issue was whether there was a legally adequate delivery of this gift. And the opinion summarized the evidence at trial, saying it was shown that Ms. Waring had great attachment to her sister, Mrs. Edmonds, the appellee, and the latter had been attentive on more occasions than one when Miss Waring was sick, whilst her other relatives failed altogether to visit her. In her last illness, seeming consciousness of her condition, Miss Waring sent for witnesses and Miss Martha Bell, with whom she lived, to her sick room, and then said, "Cousin Martha, I have 3 servants. I wish them given to my sister Rebecca," who is Mrs. Edmonds. "And the note that I hold of Washington Bell's as well, a promissory note or a bond. I wish also to give to her everything that I have. Cousin Martha, I wish you to see that she gets them." Louisa, who was about 10 years of age, was in the room at this time, and Ms. Waring pointed to her and said, "You will see that my sister has her." The witness further testified that at the time of this conversation, the other Negroes, who were small children, were at their quarters on the plantation. Ms. Waring requested that Mary Bell, at her death, deliver those children to her sister, Ms. Edmonds, and tried to impress on her that was her wish. Ms. Bell promised she would do so at the risk of her life, and Ms. Bell delivered those Negroes after Ms. Waring's death to Ms. Edmonds, who carried them to Baltimore. So analyzing this, the Maryland Court of Appeals, the Chief Judge LeGrand wrote, "If a Negro be the subject of a gift, donatio mortis causa, it is impossible for us to perceive or imagine what defect there was in the transfer of the title to Louisa, the 10-year-old who was in the room. We think also that the gift of the other slaves was completed by an effectual and perfect delivery. They were referred to specifically, and although not personally present, in addition to the donee, Miss Bell was, in whose care they were, and who was not solemnly charged to fulfill the wish of the donor." That was the language in this case that was cited to me about a dozen years ago in this century. And having read this book, it was amazing to me that the same courts who could speak so dispassionately about giving away Negro servants, Negro slaves, that same court could also grant freedom to these people. The book was a true revelation in that regard. And it discusses a number of suits, and there are like 4 families that primarily figure in the case. And for those who haven't read it, I'll just address the first one as an example. That is the Butler family. The Butler family filed over 90 freedom suits and won them all between 1787 and 1791. The basis of the suits was that they were descended from Eleanor Irishnell Butler, who was a white woman who arrived in the Maryland colony in 1681 as a servant of Charles Calvert, who was the 3rd Lord Baltimore. This Nell Butler married Charles Butler, who was a slave held by an associate of Lord Baltimore, and that happened in 1681 as well. At that time, the law in Maryland was that when a freeborn woman married an enslaved man, she and her children would be slaves. Lord Baltimore urged her not to marry Charles Butler, but she decided to go ahead, and she did marry him. He then asked the Maryland General Assembly to repeal the law that would have made her a slave by doing so, and the Assembly agreed. However, this new law applied to all marriages contracted after the last day of the Assembly in 1681, but the Butlers had married earlier that year, so she remained, that is, Irishnell Butler remained enslaved. The question then became, did the act apply to their children and to their children's children that were born after the act took effect? So in 1770, the Butler grandchildren sued for their freedom, claiming they were descended from a free woman, this Irishnell Butler. Their lawyer was Samuel Chase, about whom you will hear frequently in this discussion, and a provincial court ruled in their favor, but the appellate court reversed, not because it was wrong, but they said because the new law had deprived the slaveholders of their property rights in the slaves, and that was wrong. That was a violation of the slaveholders' rights. And that's where it stood till after the American Revolution, when the next generation of Butlers tried again. In 1787, Mary Butler sued in Prince George's County, claiming that the earlier colonial law, the 1664 law that said if a free woman marries an enslaved man, she becomes enslaved, as do her children, that law was unjust and cruel, and that the judgment in 1770 in the lawsuit involving her predecessors, that wasn't binding because that was a colonial judgment. And now we're in the United States, a new country, so not binding. She won at the trial level, Mary Butler did, and then it was appealed by the slaveholders and went to the Maryland's High Court of Appeals, and the High Court affirmed that ruling. They said the colonial court's earlier decision was not binding on the new American court, and they upheld the trial court's, the general court's use of hearsay evidence. So she won, and then her children and other Butler family members sued and won. In fact, in the October term of 1791, the Butler family won every single case that they filed seeking their freedom based on this argument. In case after case, the defendants simply conceded the matter because the Maryland High Court of Appeals had already ruled. In most of those cases, the Butlers were represented by Jeremiah Townley Chase and his cousin Samuel Chase, again, whose name will pop up. Samuel Chase was one of Maryland's 4 signers of the Declaration of Independence. He was a former Speaker of the Maryland House of Delegates, and he was a leading Federalist. And he was responsible for convincing the courts to allow hearsay testimony about the lineage of families and the status of their ancestors as either free or enslaved. So that gives you some idea about the threshold legal issues that were raised in this book. But I think I've probably spoken enough for the moment. So what I'm going to do is I'm going to take a break here and we'll move on to the next person.
Thank you so much, Judge Wallace. We'll see you again in a few moments.
All right.
Okay, so you heard a little bit about Mr. Gabriel a few minutes back. We're so grateful for his joining us tonight to be a part of this special program. Welcome, Mr. Christian.
Thank you for having me, Nick, and thanks to Renee and to Kyler. I just want to say that Judge Wallace gave a splendid sort of overview of how Maryland, in the context of the slave system, he thought that those who were freed were maybe folks who either paid for their freedom or may have been born to born to parents who had already been free, but that he did not know, neither did I, how many Prince Georgians and Marylanders had actually sued for their freedom and did so successfully. And it is worth noting that by 1810, between 1810 and 1820, a full 1/3 of all African Americans in Maryland were free, meaning they had either been manumitted for some worthy act by their owners, they had been born of parents who were free, which allowed for them to be free, or they had purchased, or they had sued for their freedom. Of course, I at this point in time, I want to say we've got a rich county. Prince George's County is enormously wealthy in way of heritage and history. On the courthouse, in the area of the courthouse, we've got Archbishop Carroll being referenced as one of the signatories to the American Constitution. He's involved in the Revolutionary War. But we also know that Prince George's County and the southern parts of the state were very much attuned to the slave system. And we had the situation evolve, and I'm moving towards the Civil War and the culmination in 1865. Mary Surratt, her house is still in the county. Of course, is the only woman ever hung by the federal government because she was a conspirator in the assassination of President Lincoln, Abraham Lincoln, shot on the evening of April 14th, 1865 at Ford Theater and dying the next morning at 7:20 a.m. at the Peterson Guest House across the street from Ford's Theater. And the gentleman who treated Booth, who ran into Prince George's County, Booth, who was a fierce pro-Confederate, anti-abolitionist figure, an actor of note, fled into Prince George's County with his associate Harold to Mary Surratt's guest house, went down 301 to Dr. Mudd's house. Dr. Mudd was a physician trained at Georgetown University. He was a conspirator and had known Booth. What's interesting was Mudd was trained at Georgetown. I did not know. As a Georgetown graduate of the Law Center, class of 1991, that Georgetown University owes its very existence to the sale in 1838 of 207 African Americans from White Marsh in Prince George's County who were sold down the river, literally sold into slavery in Louisiana. And a total sum from that transaction was $115,000 in by today's calculation, maybe about $3 million, but a princely sum in those days. And the record in the book by William G. Thomas III, the book is A Question of Freedom, The Families Who Challenged Slavery from the Nation's Founding to the Civil War. This book is just one of the most outstanding books that I've read. I want to thank Kyler Hannington and I want to thank Renee Brooks for introducing me to this book, because essentially it lifted the veil from my eyes when I thought I was rather well informed, I realized how little informed I was on a multiplicity of levels. But most importantly, the school that I graduated from, how its very existence was rooted in the owning of African Americans by Jesuits who belonged to the Society of Jesus, but who had made a pact with the devil, in a sense, in owning other human beings. And, that sordid history, of course, is a great variance with today's Georgetown University, which is usually held up as a place of exemplary sort of social outreach and inclusivity. And I'm happy to know that, I'm happy to have read recently that Georgetown University, as of 2015, is making efforts to put together a fund of $100 million. I'm not sure how far they've gotten with that. That's something that we have to investigate and secure more information on. But the effort by Georgetown today is to try to engage in a sort of reparations or reparatory justice to compensate those descendants of those that had been enslaved and whose wealth, sweat, toil, tears, and blood had sustained Georgetown University all these years. Having said that, as a practicing attorney in Prince George's County, I must recognize how in the early days, I remember reading Justice Marshall when he came to the county in the late 30s to represent an African American, was sitting up at Marlborough in the courthouse. And he was sitting in an area reserved usually for attorneys. And the sheriff came in and said, "What are you doing here, boy?" He said, "Well, I'm an attorney. I'm here representing this client." And the sheriff brandished a billy club and said, "Look, you better get out of here, boy, or I'll break this club on your head." And Thurgood Marshall, who later became Justice Marshall, had to flee the courthouse, and the family had to secure the services of a Jewish attorney, I believe, to continue the case. So, having been here now in the county, 34 years involved in my clerkship, 31 years as a practicing attorney, I have seen great transformation that reflects maturation of our society in ways of rule of law and democracy, inspired by personalities like Thomas Alvin Farrington, who was my mentor and who I started working with as a law clerk, who with people like Judge Sharman and Kasula and Jerry Devlin were, I believe, exemplary judges, exemplary jurists who, through their own compassion, their competence in law, and their belief in democracy and the rule of law and the essence of the U.S. Constitution and the Declaration of Independence and its affirmation that all men are created equal, have really sought over these years to make our county, circuit court, and district courts much more welcoming, much more open, much more reflective of the community within which we live in a way that is transformative. In that, I said recently in an article on rule of law that people in society flee from societies where rule of law does not exist, and they flee towards societies where rule of law exists. So folks don't want to live in tyrannies where you lack due process, the ability to secure bond, and the ability to file a writ of habeas corpus. Folks want to live in societies where those things exist. And what the book really showed is that, for instance, in the case of Queen versus Hepburn, where the Queens, who were a famous family here in Prince George's, and they were quite adept at using the court system, their case went all the way up to the Supreme Court, and Chief Justice Marshall at that time, who was a slave-free system sympathizer. He was a rabid and dogmatic anti-abolitionist, instituted the Hearsay Rule to thwart the efforts of the Queens, because in those days, what one would have to do to prove one's case that one was due freedom was that your antecedents resided in freedom. That is, you were born of someone who was free. And with life expectancy in the United States being in those days, maybe in the mid-40s, 42, 43, if you look at pictures of Abe Lincoln was just 56 when he was assassinated, but he looked quite much older because, things were tough. We didn't have antibiotics. We didn't have the comforts we have today. A lot of people who would maybe have to file those lawsuits to seek their freedom would have to reside in what is typically hearsay testimony, affidavits, the affidavits of neighbors who knew members who had been free. And by excluding that hearsay testimony, Marshall consolidated the slave system just for a little bit longer, because it made it much more difficult for those seeking to sue for their freedom to succeed, because they were unable to summon the requisite evidence to make their case. But what is notable is that even at the most odious time of the slave system, the amount of lawsuits that were filed and the number that was successful. And so one of the cases indicate that as far back as it says that the earliest known slave freedom petition in Maryland was that of John Baptist Moore, a Moore of Barbary, in 1653. And although Baptist's petition came 11 years before the first slave law, there is clear evidence that Marylanders were practicing black slavery even then. So there was slavery, there were suits filed by enslaved African Americans to secure their freedom, and in many instances, those petitions were successful. There's an interesting linkage between anti-slavery petitions by someone who had a mixed legacy. Francis Scott Key wrote the lyrics to the American national anthem, Star Spangled Banner, and in several instances petitioned as the attorney of record on behalf of enslaved Prince Georgians, right? However, there is evidence that the Jesuits, very concerned about his success and perhaps appealing to his innate prejudices and biases, paid him £4, 6 shillings and 4 pence to shut his mouth. They retained him to shut his mouth so he would no longer take lawsuits by slaves, many of whom were the property of Jesuits. So you see this linkage between the Jesuits as an order and Francis Scott Key, who had been a petitioner, or at least the advocate for petitioners in lawsuits seeking their freedom, and then the Jesuits actually procuring his complicity in the slave system by buying him out. And of course, he became a member of the American Colonization Society here in Maryland, Prince George's in particular, advocating for African Americans who were free not to remain in Prince George's County. He felt that the retention in the society of freed African Americans was counterproductive, was corrosive in its effect on the slave system. And so that the sooner we could rid Maryland, Prince George's in particular, of those pesky freed African Americans who were so impertinent as to believe they could use the system of due process to secure the freedom, the quicker we could get rid of them, send them back to Africa, the better it would be for all of us, meaning all white slave owners and those who were complicit in the system of slave ownership. But I think it's a tribute even then, at a time of chattel slavery and white supremacy thinking, that Black Prince Georgians, that book is spectacular. And I urge those who have not heard of it to get it. A Question of Freedom, that Black Prince Georgians had the pluck, the intelligence, the industriousness, and the drive to find ways to petition courts here in our county and other parts of Maryland to secure their freedom. And the fact that a major university, major regional university, major national university, a major international university, Georgetown, had its very existence rooted in the sale, that massive sale of 200 slaves back in 1838. I cannot comment enough on how profound a discovery that was for me, and how I think it behooves us as supporters of the Prince George's Office of Human Rights. Maybe we can make that a special project and find ways to engage Georgetown in ways meaningful. I'll stop at this point in time. There's so much more to come. But I'll conclude on this very interesting fact that I think we ought to know, and I give credit to COVID in a sense, which allowed me to read more books than I ordinarily have time to do. It was during COVID that I discovered the name Josiah Henson. Josiah Henson is the gentleman on whom the book Uncle Tom's Cabin was based. And he was born right here in Brandywine, Prince George's County, Maryland. More on that later. Remember the name Josiah Henson, because it is his story that was used as the basis. You know, he did not file a petition to seek his freedom. Although he had money to buy his freedom, his master sought to deceive him because he was not literate, and sought to keep the contract that his freedom papers away from him. He walked all the way with his family from Prince George's to Canada, which is where Kyler Hannington is from, because Canada, being a British colony, slavery was, of course, not at that time allowed in Canada. So many African Americans, many Marylanders, Prince Georgians made their way to Canada via the Underground Railroad. And the gentleman who gave forth the facts that made Harry Beecher Stowe, author that famous book, which its zenith exceeded in sales that of the Bible, Uncle Tom's Cabin, was from right here in Prince George's County. So we ought to have a commemoration sometime through the Office of Human Rights in honor of the legacy of Josiah Henson, who was not an Uncle Tom. He was a hero, an anti-slavery hero. So I thank you at this point in time, so we can have a little more dialogue. I thought what Judge Wallace said was enlightening. I hope what I said was fruitful. Thank you.
Well, thank you. Thank you both. Both of your presentations were outstanding. And I'm just going to quickly hold the book up again. We urge you to get this book, either check it out from the Prince George's County Memorial Library System or purchase it. It is a must read. And I think that the book really highlights the complexities of the issues of slavery, but I think it also highlights the complexities of the issues that we're still grappling with as a nation. And so with that in mind, I want to talk a little bit about Gabriel Duvall, who has a wing named after him in our courthouse here in Prince George's County. And he was a complex character, right? Because he defended or represented, I should say, people who sued for freedom. He also defended slave holders. He was a slaveholder himself. And he also wrote, when he became a justice of the Supreme Court, he wrote a really interesting dissent that was quoted in another freedom suit, but basically saying that, freedom, let me see, I wrote it down so I got it right. The question of freedom surpasses any question of property. So I was just curious about both of your thoughts, just really unpacking the complexity that is Gabriel Duvall. What do you think?
I agree, Renee. It was, you see all these names. Gabriel Duvall is another one who, when Samuel Chase went on the bench, became a judge, Gabriel Duvall and Philip Barton Key, who was the uncle of Francis Scott Key, kind of picked up the torch, and they represented a lot of these people. And Duvall was a strong advocate, won lots and lots and lots of cases freeing enslaved people. By the time Queen versus Hepburn, the case that Mr. Christian talked about, got to the U.S. Supreme Court, Gabriel Duvall was on that court. So you had John Marshall, who was the Chief Justice, himself owned about 150 slaves, and he wrote the opinion saying, no, this hearsay doesn't come in. And Duvall said, who himself owned slaves, he said, wait a minute. We've long admitted hearsay in cases of inheritance pedigree cases, they called, or were there controversies regarding boundaries and land? And it seems to me that if it's admissible there, it certainly ought to be admissible in these cases where we're talking about people's freedom, which certainly means more than where's the boundary of the people's property or what, how much they inherit, whether you're a person. So he was that strong advocate. But after Queen versus Hepburn, which kind of eviscerated the freedom suits, the ability to bring them on the grounds that had been brought before, then the cases started being brought in a different manner. Now, politically things had changed, so there was more talk about abolition and more support for that. And so then the lawsuits took on more of a political tone. And 15 years after Gabriel Duvall's dissent in that Queen versus Hepburn case, Thomas Butler and his family filed a freedom suit against, guess who? Gabriel Duvall. And he said, so Duvall, who now is on the defensive, says, and they filed in DC, he said, no, DC, you have no jurisdiction in that case because I'm an official resident of Prince George's County, Maryland. The trial judge in DC said, nope. And he said, and I quote, wherever the master exercises his power over the supposed slave, there the right of action exists. So wherever you're maintaining your power over a slave, the slave can file his freedom suit. So that didn't prevail for Duvall. They went to trial, and the grounds now was that Duvall had bought their family, the predecessors in DC, and imported them to Maryland. Now, slaves were permitted in Maryland, but you couldn't import them to Maryland. So having done that, that was illegal. And they won their suit. So Duvall lost the Butler family of 8 slaves, and he had, I think, only 32 or so at his plantation, Marietta, which still exists. It's near the corner of Enterprise Road and Annapolis Road there, near the Fairwood, that big new community. So he was on both sides. And the same is true with regard to, I think it was Philip Barton Key rather than Francis Scott Key, who took a bribe or didn't take a bribe. He, having won several for the enslaved people, then was hired by the enslavers, the Jesuits, not so much because they wanted him advocating, but they didn't want him on the other side. So that happened. And there were several instances of that kind of flip-flopping going on throughout the history. Some people through the book, they say sometimes maybe these lawyers were taking these suits because they thought they were good suits and they would get paid. They would get a fee because in addition to being released, the enslaved people would get damages. And the lawyers could recover a third of those damages, just like, in a personal injury case today. So some people may have been bringing them just because it was good business. They could make money doing it. Some people clearly did it for philosophical reasons. But even those who didn't necessarily believe in slavery, oftentimes they were members of the colonization society that the Gabe talked about, Mr. Christian. They were saying, let's just move them all back to, yes, slavery is a bad system. Let's abolish slavery and move all those slaves back to Africa, even if they had never been there. Their families hadn't been there for 100 years. And so colonization. So there were a lot of people who had that philosophy too. So there were people that had mixed positions on a lot of these cases. And the book kind of brings that out. And the litigation that was going on kind of brings that out. The other, I'll leave it to Mr. Christian to comment more on that aspect. And then there's another one that I thought was interesting too.
Okay, we'll circle back then. Gabe, what do you think?
Oh, I mean, it's just fascinating. And Judge Wallace is correct. It was the uncle of Francis Scott Key, Philip Barton Key. In fact, the language was that the account book for St. Thomas Manor. So the Jesuits owned in Prince George's several manors, which were like us, housing arrangements where the Jesuits would live, and they would have their servants, and they would also serve as innkeepers as well, because they were very, say, entrepreneurial. So they earned money by having plantations in the county, having these manors where people who were traveling, like Motel 6, maybe the 17th, 18th century version of Holiday Inn Express. So one account book for St. Thomas Manor said, and I quote, "To retain or stop the mouth of Lawyer Key from speaking in favor of the Negroes who have sued for their freedom. To deal with the situation and to prevent further petitions for freedom from their enslaved laborers, the Jesuits took quiet but decisive steps, borrowing money from the general fund of one of their congregations." So that's, folks putting money in for the Lord, and that's what it's going to. They paid Philip Barton Key to stop representing enslaved families on their plantations. Key had won the successful judgment from Ned Quinn, one of the famous Quinn family, on May 23rd, 1794. And 3 months later, in August, the account stated to retain and to stop the mouth of Lawyer Key. So you see here a really well-documented family. The Queens are making, efforts through the law courts, sometimes successfully, and to the consternation of the Jesuits, they're doing much too well, and so they've got to take away from their service one of those lawyers, Philip Barton Key, the uncle of Francis Scott Key, who wrote the lyrics, to the American national anthem. I want to also note something that I said earlier. It's said in some of the reports that I read in the book, as well as the studies I did on the Hepburn case, which is really an important case on the hearsay rule that Judge Wallace alluded to, which really sought to cut off that nexus between those who had passed on and people who could give affidavits about the genesis of the freedom of someone who is petitioning, is a growth. So let's put it this way: the success of those suits proceed pari passu, as they say in Latin, at the same time as you see a demographic shift. And Judge Wallace, I'd like to kind of get his input on this. It says here that the number of free blacks in Maryland grew steadily from between 1783 to 1810. The growing free black population mostly liberated by petitions for freedom. That was something that was amazing. I would have thought that it was a little different, that they were either, freed for worthy acts, as you'll call it, faithful service, or born into families that were freed, but mostly liberated by petitions for freedom. That means all law courts, even in the darkest days of chattel slavery, provided an avenue, because we had jurists who were willing to look at the law and not at the prevailing biases and prejudices of the time. That growing population offered a visible, meaningful, and stark contrast to racial slavery. In 1800, 15% of all Maryland African Americans were free. By 1810, when the Queens filed that lawsuit, their petition for freedom, there were 33,927 free blacks living in Maryland, 30% of all Maryland African Americans. That was something that was so powerful. Now, what I want to say, and Judge Wallace, you can chime in on this, in an election that I think Francis Scott Key was involved in to the General Assembly, he lost by about 7 votes. I did not know that freed African American persons were allowed, freed African American males were allowed to vote in Maryland elections. So, Judge, please.
And yes, it was kind of secular. As they were enslaved, there was no need to have a law that say they couldn't vote.
Yes.
Right?
Right.
As they became free and then began to vote, to see, we're going to have to change that. We're going to have to address that.
Yes.
And so those laws changed. The same thing was true. There was never a provision about slavery in the Maryland Constitution until after these suits were becoming successful, and in 1836 is when they amended the state constitution to provide, quote, the relation of master and slave in this state shall not be abolished unless by a unanimous vote of the General Assembly and by paying full compensation to the slaveholders. So that only became a law as the reality of freedom kind of arose. The other thing that's interesting is this issue about hearsay. Our modern hearsay rules, currently, the exceptions to the hearsay are in Rule 5803-19, reputation, hearsay which involves reputation concerning personal or family history or heritage is still admissible, and reputation concerning property boundaries is still admissible. The same things that Gabriel Duvall was talking about 200 years ago. The other interesting thing on getting back to people with both sides, we all know of the name of Roger Tawny, right? He was the Chief Justice of the Supreme Court who wrote that infamous Dred Scott decision.
That's right.
But 20 years before that, when he was on the U.S. Supreme Court, when a freedom suit came before him, they had won in the trial level, and it was appealed, and it came before him. He ruled in favor of the enslaved petitioner. And in that case, the issue was the slaveholder had inherited the slaves from his aunt, and the aunt's will said that he could inherit all her slaves with the proviso that he shall not carry them out of the state of Maryland or sell them to anyone. In either of which events, I will and devise that the said Negroes to be free for life.
That's right.
Well, he had followed the direction for quite a while, and he didn't sell them. He hired them out to other people, kind of rented them out. However, at some point, he sold one of them, James Ash, and James Ash sued, saying, well, now I'm entitled to be free because that's what the will said. And he said no. And Justice Tawny said, look, whatever property right you may have in the body of James Ash, it ended when you sold him because you only got him under these conditions. So again, you've got somebody who would issue just a terrible decision against Black people in our country, but also ruled in favor of them on a narrow property analysis issue. So you have people on both sides. It's really kind of interesting. And to see all these names that pop up and that we know of from our history. And again, as Gabe said, right here in Prince George's County. It really is amazing to think about it. The other aspect that was of a legal thing that I thought was interesting is when these cases started being successful in the general court, where at one point Samuel Chase sat as the chief judge, and those general courts were broader. They covered larger geographic areas, some slave, some not slave holding. The General Assembly said, this is not working for us. Henceforth, all these cases have to go to the local county courts. And every county court judge at that time was themselves a slaveholder.
That's right. So
just by changing the jurisdiction, one, you would think it really doesn't have any, that's just administrative stuff. They completely changed the success rate of these lawsuits. Although still many families, the Queens among them, the predecessor to Queen versus Hepburn, sued in Prince George's County courts and still prevailed. But there was the monkeying around with the jurisdiction that I thought was interesting. And
go ahead. No, please.
No. Did either of you note that there was also the kind of the gossipy story about a county judge in Queen Anne's County? So when they changed the jurisdiction, this came to pass. One of a lawyer in Queen Anne's County went to the local county judge and said, I'm filing a freedom lawsuit against you because you own this slave that I represent. So the judge says, I will give you 4 or 5 guineas, and if that will not be enough, I will double it. If you will let the lawsuit fail and tell everybody it's because the testimony was not believable.
Yeah.
And so not only was he corrupt, but he was a bad negotiator.
Yes, indeed.
I'll give you 4 or 5 guineas, but if that's not enough, I'll give you 10.
No, yeah.
It really made you wonder.
No, the book, there's so many things to unpack through the legal lens. A couple of things I wanted to say. The thing that you mentioned in your presentation, first of all, Judge Wallace, about sort of how the butlers were able to play on the fact that, we beat those British people, so now we shouldn't follow them. Yet, we still follow British common law. So it's just like this weird half-truths, truths, or narrowly refining or defining something, right? So I just thought that was sort of interesting. The other thing I wanted to, I'm sorry if you want to comment on that.
That is interesting. We still follow British common law to some extent, and DC follows Maryland common law because DC was once part of Maryland. We all know that it was the other side of DC, which was given back, was part of Virginia. And so they followed Virginia common law. And the interesting thing was when DC was a full square and both Maryland side, both sides of the Potomac,
right,
you couldn't bring a slave from Virginia, from the southern side of the Potomac in the DC to the northern side of the Potomac in DC, because then you would be bound by the Maryland law on importing slaves. So even that, they couldn't go,
right,
across the river, even though it was all the same city.
Yeah. So it's interesting, we're reading, this is the county read. So we get together every month. And when we were doing chapter 5, this came up and I couldn't remember the answers. So for anybody that is listening from the county read, Judge Wallace just gave the answer to a question that came up about that very issue, DC, Maryland, Virginia, and some of the rulings. And I'd forgotten that DC follows Maryland common law. Fascinating. I want to say one other thing. The Marietta house that you talked about, that was Judge Gabriel Duvall's residence. They actually gave us, and we asked, a wonderful video to show, but it was too large to show. We were going to show it here as sort of a taste. But for anybody listening, please, on April 7th from 4 to 6, Marietta House is doing a program. It's both virtual and hybrid, as I recall. You can go in person or virtual. And they are really unpacking the voices of the enslaved people there at that house. We have so much to say, but we're out of time. But Gabriel, did you want to say something?
Sure. I think it would be maybe churlish of me to not chime in and add, a little bit about Lord Mansfield, because while we didn't have internet and Google, news traveled and precedent was followed, and because the United States has its root in Britain and was a British colony, the Mansfield decision. In the case, it was Somerset versus Stuart. It's a 1772 case, so that's before the Revolution of 1776. Somerset was an African American who was brought to England by his master.
Yes.
And one of the abolitionists, Claxton, absconded with him, got him baptized as an Anglican, and the old sort of shibboleth was that Black people had no souls, and that's why it was okay for Christians to enslave them. But then if they were baptized and they were Christians, then they had souls, and so everything changed. So Claxton, they got Somerset baptized, and they filed a petition, and it went all the way up. And Mansfield, his famous ruling was as follows. And I say this because Mansfield was cited in the 1797 case here in Prince George's County by Charles Mahoney, who filed a petition for freedom against Ashton in Prince George's. And Mansfield, who was cited in the argument, said, quote, "The state of slavery is of such a nature that it is incapable of being introduced on any reasons, moral or political, but only by positive law, which preserves its force long after the reasons, occasions, and time itself from whence it was created is erased from memory. Quote, it is so odious that nothing can be suffered to support it but positive law. Whatever inconveniences, therefore, may follow from the decision, I cannot say this case is allowed or approved by the law of England, and therefore the black must be discharged." So Somerset got his freedom. And in the case in 1797, which would have been about maybe, about 12 years afterwards, Philip Barton defended the slaveholding Jesuit. And at that time, some of the most talented lawyers in Maryland lined up to argue the Mahoney case, including some of Key's rivals. And Richard Ridley, one of the most distinguished Maryland attorneys of the day, argued in 1799 that slavery, I quote, is incompatible with every principle of religion and morality. It is unnatural and contrary to the maxims of political law, more especially in this country where we hold these truths to be self-evident, that all men are created equal. And Mahoney's other attorney, John Johnson, joined Ridley in this argument and drew heavily on the Enlightenment ideas about universal rights and repeatedly cited Lord Mansfield's decision in the famous Somerset versus Stuart case. So what we see here is, even in the darkest days of chattel slavery, a sudden reaching towards due process of law, and trying to use the force of reason, logic, of course, buttressed by a certain degree of morality, rooted again in the Judeo-Christian ethic, to say, guys, look at the Declaration. If you post 1776, or if it's prior to 1776, go back to the Bible. What you're doing is wrong. And the courts, our law courts, in Prince George's County and other parts of Maryland, countenanced those lawsuits and allowed African Americans to petition. Not just petition, but to petition and win, even at jury trials, as opposed to just simply bench trials.
Yeah.
So there was a certain degree of respect for the importance of a judiciary. And I believe that, frankly, if you go now into Brown versus Board and all, the progeny and all that, that is what remains one of our greatest saving graces as a society. And that is why I do believe, in many respects, offers the world a gold standard, that we can tussle with such complex issues. And those issues are being addressed somewhat successfully, as in the Queen and, certainly Mahoney and the Queen family's cases, before the Civil War.
Yeah. I for people who know me, history, I love history. I think history is so important, because if we don't, I'm just saying what everyone says, if we don't understand the past, we cannot understand how to chart the future. We certainly don't understand where we are. And so I really, sort of as a last thought from each of you, what do you think we have learned, or what are some of the lessons that we can take, especially now, because we're sort of in this struggle again with very similar issues, with the reawakening of civil rights and examining systems of inequity that exist for whatever reasons, and how they have, whether we're talking about banking or home ownership or, whatever it is. What is it that we can learn from this book, from this particular history, and where we are now and what our future is? So please.
Judge Wallace seniority.
Oh, that was smooth.
That's him saying that I'm older. So, I mean, the first thing you can learn, I think, is that history is cyclical, that these things do keep coming around. And the second thing is that it's very important to have a strong and independent judiciary. And you learn that that they were kind of a bulwark against the popular system. You know it now that sometimes the courts are the only ones that are stopping some terrible things from happening. And so they're really important. And unfortunately, I think some people don't recognize it and don't think about it. There was a reference to the fact that I had run for election twice. You know, people don't know who judges are. They don't have any idea. They know people often know who's going to be president, or who they want to be president. But the reality is that whoever's in the White House often doesn't have nearly as much impact on their lives as a judge who they may come in front of in Upper Marlboro.
That's right.
But those judges are selected often by people that have no idea what those judges are like and what they're going to be doing. And it's so important for people to educate themselves about that, I think, is one lesson that we can learn.
Yeah. Such great points, Judge Wallace. Thank you for that. Gabriel, what are your words of wisdom?
The power, as Judge Wallace said, of a strong judiciary and of a framework of rule of law, that the ordinary citizen is Caesar. That means the ordinary citizen is invested in. So while it's true the ordinary citizen may not know who Judge Sean Wallace, who he is, because they don't come to court often, they're not part of the Prince George's Bar, but they live in a society where his decisions percolate through the ether and give texture to the community within which they reside. And I bet you bottom dollar, if he, on one bad day or on in one fell swoop of 3 or 4 weeks or months, began to act in a fashion that cut across the grain of human freedom and the dignity of his office, bet your bottom dollar, they would know. They would then become interested, and through their political power would do something about it. So we are in a situation where, as the judge said, the courts represent sometimes the last bulwark. In the recent election petitions after the last election, not one petition succeeded. And I don't think it was because of judicial bias, because many of the judges were appointees who'd been put in there by Republican presidents on the federal bench, some of them by President Trump himself. It did not matter. They were unwilling to deviate from the black letter law, and they followed precedent. Now, precedent isn't all wise and seeing. As Judge Wallace mentioned, we had Justice Tawny, we had Dred Scott, and we had Plessy versus Ferguson, and we had Brown versus Board. So we see a transformation. But the point he made a while ago that's so important is that history is cyclical, and so you can have regression. Victory for progressive ideas or for rule of law or for democracy is not certain. It only is ever living where we pay homage to the temple of our freedom, which I believe resides within our law courts. When I walk down Main Street to Upper Marlboro, I drive by with my family and I look at the Gresham columns. It's in few societies, courthouses are spotlit and are held up. In many societies, it's the presidential palace or some statue to somebody long gone. In the United States, where there is a reverence for, like when jurors come in, these are people who come from disparate backgrounds, and they sit there and they listen to the judge instruct them, and they listen to the facts. That is something that is rare across our world and is powerful. And so what comes out of this discussion is that I think the Office of Human Rights, which you lead with great majestic effort, and that with Kyler, Huntington, and Nick, represents an opportunity to use these cases from this book to educate our society in civility, the importance of rule of law, the importance of civic virtue, of volunteering, to show up for jury duty, don't give an excuse that you got a bad back or bad toe, and to continue to understand why we play an important role by showing due reverence for judges and those who occupy the judiciary, because that might just be the last bulwark between living lives in freedom or living lives in tyranny or in a tyrannical state. And so I want to thank a good judge, and I want to thank my fellow litigators and all those folks who work at the courthouse, because in the darkest days, folks were able to go in and file freedom petitions. That was an amazing revelation for me. I knew that freedom petitions had existed because that was Dred Scott, but the prolificity of it, the volume was something I was totally unaware of, and that was really heartening, really heartening.
Yeah, so thank you for your words as well, Gabe. And I echo, when you're called for jury duty, please don't try to get out of it. It is your civic duty, but I think this discussion really shows the impact that you have as a juror. So thank you so much, Judge Sean Wallace, Esquire, and Gabriel Christian, Esquire, for your contributions to this continuing conversation about a question of freedom. And we looked tonight through the lens of the law. We're going to invite Kyla, so again, thank you for reading your profound statements, your insights. I think we could have probably 2 more discussions just based on this book. But thank you for staying longer. And Kyla is going to close for us.
Could I ask a question before you do?
Yes.
When is the play?
So it is 20. I don't think the date has been set yet, but we will certainly keep everybody informed. We have lots of different events before that, and we hope to, have sort of a summation at the end of the 2 years with sort of a panel discussion. So stay tuned.
We have much more coming up, and we mentioned during the course of this that there's a Prince George's County Reads, where we look at a chapter of a book at a time. It is the first Tuesday of the month, so it's actually coming up next week. You both will be welcome to join us, of course. I will send you invitations, but also for those people listening at home, if you go to pgcmls.info/events, they have a wonderful event webpage that you can go through day by day. And our friends at Joe's Movement Emporium, who are co-hosting this with us, also have a whole website devoted to freedom stories, which is the series of events around which this book is based. And so we also direct you there to look for specific information regarding upcoming events. Renee.
Yes, I just, Brooke Kidd, the executive director of Joe's Movement Emporium, said to look for a workshop in June. So that's a direct response to your question, Judge
Thank
Wallace.
You.
And for those,
I'm looking forward to that.
For those at home, Nick from the library has put in some links for you also to look at for those freedom stories. And Mr. Christian?
Yes, Judge Wallace may not have it yet, and I want you all to get it. The name of the book is The Road to Dawn, D-A-W-N. Josiah Henson and the Story That Sparked the Civil War. Josiah Henson, during COVID, I came across this Smithsonian article, was the figure from Brandywine, Maryland, Prince George's County, Maryland, on which Harriet Beecher Stowe based the book, Uncle Tom's Cabin. And there's a piece that has to do with Kyla, and I gotta say it because it's so important. When he goes to Canada, he becomes so famous. He owns a lumber mill that he's sent to the World Fair in England, where he's given a gold medal by Queen Victoria. But before that, I did not know there was an uprising in Canada where there were extremist pro-slavery Canadians who wanted to partner with the South. So Canada would have become a slave state. And guess what happened? The African Americans formed a battalion, a military unit that worked and fought alongside the British Army to keep Canada as a free country. And one of the commanders was the Prince Georgian, Josiah Henson. The author is Jared Brock, Jared Brock, Brock. I think it would be a wonderful thing. I've spoken with him to try to get him on this program with Judge Wallace and myself and somebody else. But it would be a great addition, so folk can know the contributions, plural, of our county to the shaping of American democracy and rule of law.
We're going to put you on retainer. We don't have any money, but we're going to put you on retainer.
Right.
For the
Well,
office of
I'm
It may be a
sold on
little-
that event. Sorry.
No, but it won't be to have me shut my mouth. As with Philip Barton Key, that was an amazing,
Yeah,
Yeah.
it's fantastic.
Well, this has been wonderful, and actually, I will be in touch regarding that book and seeing how we can just continue working together. You've not been able to see the chat that's been coming in. We haven't flooded the screen with comments, but we have been seeing them in the chat box where people have just loved the conversation. Both of you have contributed so much, and we really could probably keep this going all night. But in the interest of everyone's time, we're going to end it now for this conversation. We'd love to have you back. And I do want to take a few minutes just to thank both of you for your diligence. You read the book, you studied it, then you thought about it, and you came and you volunteered your time tonight to be with us, to honor the work of Dr. Thomas, this book, and the people who mounted these suits in Prince George's County. And so thank you both for your time and effort and kindness to this work. Really appreciate that.
Truly been a pleasure. Thank you for inviting me.
It's been an honor and privilege, and certainly, Judge, fantastic. And it's great listening to you and Renee and Carla. Thank you all very much.
Absolutely. Thank you.
It's been an honor. The Prince George's County Office of Human Rights, along with Prince George's County Memorial Library System, Joe's Movement Emporium, and the Prince George's Community College Center for the Performing Arts, have all been working together on these initiatives under the banner of Freedom Stories. As I mentioned, we do have Prince George's County Reads next week, Tuesday. Please come and join us. We'd love for people to tune in for that. Yes, Renee? Did you have
Just one thing. Very often, the author drops by during these reads. So just throwing it out there.
He's a Prince Georgian, right? His family
His family. Absolutely.
Right.
Yep.
Amazing.
And we invite you to check out other upcoming events from our office at tinyurl.com/PGCOHR events, and always check out what the library has going on at pgcmls.info/events. We welcome feedback on all of these in our programs. And again, we just really want to take the time to thank those of you watching at home, our event partners, and particularly Renee Ballabrooks, Gabriel Christian, and Judge Wallace. Thank you so much for being with us tonight.
Thank you.
All right, everyone, stay safe.
Good night,
Bye-bye.
everybody.